Good morning or good afternoon. We will begin our webinar in 1 minute. Good morning or good afternoon. Welcome to the National Consortium of Telehealth Resource Centers Telehealth Hack Series, Licensure and Provider-Patient Relationship. Next slide, please. The NCTRC Telehealth Hack does collect some of your information. We just want to assure you that your individual data will not be shown to anyone and will be kept confidential. Next slide, please. National Consortium of Telehealth Resource Centers are made up of the 14 telehealth resource centers who are funded through a grant from HRSA. There are 12 regional resource centers that cover specific states and 2 national centers that cover policy and technology, respectively. Next slide, please. For those of you who attended the ASPR hacks that were done over the summer and into September, those hacks had a time-limited 10-week period and with 1 bonus week, and were transitioned over to the National Consortium of Telehealth Resource Centers in October. We will continue these hack series until March of 2021. Next slide, please. A few tips and notes. Your phone and your computer microphone has been muted. If you have a question, please use the Q&A function. The chat function should only be used if you are needing technical assistance with Zoom. We also ask that you please put your questions in the QA, as I mentioned. You'll be able to adjust your Zoom settings with the sliding feature, which is at the bottom there. And please note that the webinar will be recorded and posted later on our website and our YouTube channel. Please also note that we ask that you refrain from any type of political comments in the chat or the Q&A section, and please do not do any advertisement in there. We try to keep this as a, learning zone only and keep political conversation out of it. Next slide, please. We do have continuing education credit. It is done through the University of Arkansas. This is a disclosure policy. Next slide. And more information related to that. Next slide, please. Next slide, please. And this is the information that you probably need the most. So to access and get your credits, you will need to go to this URL. Again, the PowerPoint will be made available as well as this information will be on the consortium's website, but you will need to create a profile. It's the Learn on Demand website, and you create a profile, and that will allow you to complete your registration form for attaining credits. Once you have created this profile, if you attend a future hack and you wish CE credits, you do not need to create a new profile. So it's just simply the first step that you need to take, and you create that account, and that account will stay open for you for all of the future hacks as well. Next slide, please. And this is just more information regarding how to get your CE credits. And the next slide. There is a deadline. You will need to complete it by November 24th in order to be assured that you'll receive those CE credits. Next slide. And again, just additional information, and this PowerPoint will be made available to you, so don't worry about copying it down right now. Next slide. So for today's agenda, we have a stellar lineup here of 2 very knowledgeable people to talk about the subject. So first off, we'll hear from Amanda Enyeart and then from Joe McMenamin. Next slide, please. We have, I believe, a short poll that we want to take before we get to Amanda's presentation. So right now, we wanted to see what is the familiarity of telehealth policy or legal issues related to telehealth that the audience has. So your choices are extremely familiar, moderately familiar, somewhat familiar, or not familiar at all. So if you would just take a couple of seconds to let us know like where you are with your familiarity on legal issues as they relate to telehealth, that would be really helpful to our speakers. Just take a few seconds here. Right. And it looks like there's some familiarity there. So that's actually a nice starting point. Moderately familiar is at 33%, and then extremely familiar is at 6%. Not familiar at all is at 11%. But half of you are somewhat familiar with at least some of the legal issues related to telehealth. So that's really good to know. So great. So we will now get to our first speaker. So Amanda is a partner at the international law firm of McDermott, Will, and Emery. She focuses her practice on advising clients on digital health issues, including privacy and security of data, data governance, technology implementation, and telehealth programs. So I will now turn it over to Amanda.
Great, thank you very much for that introduction, and thank you all for participating in the poll. It's nice to have a sense for where everyone in the audience is with respect to the legal issues that we'll be bringing to you today. Let's go to the next slide, please. So today I have been asked, and we'll talk about licensure in telehealth. Next slide, please. I have a couple of objectives for this presentation. Generally, I would like to just set forth the framework that we look at when we're looking at licensure issues from a legal perspective. Kind of give you a sense of how the federal and state governments are playing together with respect to licensure requirements, or what the expectations are with respect to licensure. And then, of course, because of the COVID-19 public health emergency this year, we'll take a look at both what the federal government and what state governments have said and how they have acted with respect to licensure in telehealth in order to kind of free up the ability of providers to provide services via telehealth technologies. So we'll start with looking at just the traditional licensing regime, which is here on just summarized here on this slide. And what's important to note here is that the federal government, the state governments really have the ultimate authority for determining what the licensure requirements are for the providers who are providing healthcare services in their states. And this is regardless of what type of healthcare provider we're looking at. We're going to try to address all sorts of healthcare providers, including physicians, nurses, therapists, social workers, all of the different types of healthcare providers that might be providing services through telehealth technologies. So the states have this authority through their the reserved powers that they have under the 10th Amendment of the Constitution. Generally within the states, then the responsibility for licensure is delegated to licensure boards. These might be medical boards, nursing boards, or just general departments of health, depending on how the state has apportioned those responsibilities. The federal government could have some say in licensure requirements through the application of the Commerce Clause, particularly as licensure, as telehealth grows and there's more interstate commerce and interstate actions with respect to provision of telehealth services. We haven't seen grand declarations of that, but that is something just to keep in mind. The federal government may have some ability to affect some of the licensure regimes through that Commerce Clause authority. But generally here we really are looking at the states as the ultimate authority. The federal government does take licensure requirements into consideration when certain policies are and requirements are being drafted. So for example, Medicare and Medicaid both require that a provider be licensed and appropriately licensed for the services that they're providing in order to receive payment for those services. So there is some interplay there, but the federal government is generally not dictating the requirements with respect to licensure. And then just importantly to note, the federal government does regulate some of the areas that we'll be talking about in this series related to telehealth, such as controlled substance prescribing, which I think will be addressed in a later part of this presentation. Next slide, please. So the general rule that we recognize with respect to licensure is pretty straightforward and pretty fundamental, and that is that when a provider is providing professional services, so these are services that are within the scope of the professionals practice via telemedicine across state lines, that the provider needs to actually have a license or be otherwise authorized to furnish treatment in the state where the treatment is being delivered. And generally, we see that as the state in which the patient is located at the time of treatment. And so there may be some residency issues as well, but our general rule is that if a patient is sitting in California and receiving telemedicine treatment in California, then the provider needs to be authorized somehow to be providing that service within the state of California. The traditional licensure pathway is for a full licensure, which would be that, as if the provider is licensed in only one state. So that would be the full application, the full background check, the required examinations, all of the aspects of licensure that would be required to have a full licensure. But states have recognized generally that there are some exceptions to that, or have introduced some exemptions to that general requirement. For example, there can be cross-border reciprocity and endorsement deals or perspectives, so that certain states might provide that a provider in a neighboring state that is providing services within a certain geographic location within the state can provide those services with their home state's license. And that's, traditionally in an on the ground program, so that you can cross borders in order to provide services in another state. There are also endorsement and reciprocity requirements that might permit a healthcare provider who's licensed in one state to have a much less onerous application process to get licensed or otherwise authorized to provide services in the second state. And the third way that we see kind of a loosening of this is the licensure compacts, using the Interstate Medical Licensure Compact as an example. There are 29 states plus the District of Columbia and the Territory of Guam who have signed on to the Interstate Medical Licensure Compact, which allows a provider who is licensed in one of those states to get licensed relatively easily using a uniform application process in the other states. And this really can facilitate the ability of a provider to provide services in multiple states without being required to go through the full licensure process in all of the states. Next slide, please. I think there was a question about exemptions. So I'll talk about some other exemptions to full licensure. And these are exemptions that states have recognized that there might be a reason to allow providers to provide certain services within your state without having a full license or without having a license at all. The first example I'll give is telehealth only license or registration, and Florida and Minnesota are examples of that. Florida, relatively recently, within the last year and a half, implemented a process to register telehealth providers within the state. So it's not a full licensure process. Minnesota also has a telehealth only pathway as well. And then outside of the specifically telehealth world, there are practice exemptions that might apply to the practice of telehealth, the practice of medicine or other professions via telehealth technologies. And these are things like peer-to-peer consultations, which would allow a healthcare provider in one state to consult with a specialist in another state, without that specialist in the other state being required to have a license to provide information or treatment or information about a specific patient in the state in which the patient is located. There are some limitations in these kinds of exemptions. There can be frequency limitations. There can be limitations that don't permit this type of consultation if the consultant or the consulting physician in the other state is being paid, for example, or seeking reimbursement for the treatment. So states treat these differently, but these are the types of exemptions that might be provided. Other types of exemptions would be the pre-existing patient. So you're already treating a patient who happens to be traveling outside of the state, and they call and need some assistance. There are many of the states provide for that, or also follow-up treatment if the patient is treated at one facility in a state and then goes home to another state. There are some states would permit the treating physician to be able to continue the follow-up treatment in the home state of the patient. And then finally, there are definitely the waivers that we've seen that we'll talk about a little bit more extensively later in the presentation. And I see that there's a question about the reference to providers. Here, I'm talking generally, so I'm often using physicians because that's the regime that we're most familiar with dealing with, or I am with my clients. But definitely there are allowances in other professions as well. So as everyone I think on this call knows, healthcare providers of all sorts are using telehealth technologies in order to deliver care. And so we've got behavioral health providers, nurse practitioners, physician's assistants, and physicians. So I know I'm talking very generally, but in many cases, these apply to multiple types of providers, these exceptions and these licensure requirements. And we can go to the next slide. So I realize that this is a very tiny slide, and it's something that you can take a look at when you get access to the slides a little more closely. But what I wanted to do here is to provide kind of a framework of how we might analyze whether a license is required, or whether a provider, and in this case, I believe it's a physician, would be permitted to provide services in a certain circumstance. And it starts with the top darker blue box on the top, which is really looking at what type of service is being provided. And so the first aspect to look at is what the provider wants to do, actually the practice of his or her profession. And I don't have a separate slide on this, but I think it's an important point to consider if a physician or a nurse wants to provide general information in a format such as a webinar, where there's not specifically a one-to-one conversation, where the information that's being provided is more generalized, there is definitely the argument that that person is not practicing his or her profession at that time and would not have to be, would not need a license in order to provide the information that they're providing. But the closer you get to one-to-one communication, actually talking about a specific patient, is the closer you get to actually practicing the profession. And so those are the cases where you really start to look at whether a license is required for the activity that's being proposed. And so this diagram just does take a look at different scenarios and whether any of those exceptions apply that we just discussed, just in general terms. So whether there's an exemption to a licensure requirement, whether there's an easier pathway to get the licensure, or whether the provider would just ultimately have to have a license in the state in which the patient is sitting. So there are multiple pathways to get to provide services in other states, but it's a complex and kind of a complex calculus that you need to do to see if there are exemptions that would permit the service. Okay, I think we can go to the next slide, please. And then the next slide. So we'll talk a little bit about what happened with the COVID public health emergency this year. So starting with the federal government, and I had talked about the fact earlier that the federal government doesn't actually have authority over the licensure requirements from state to state, but we did see in March that the CMS came out with a declaration saying that they were not going to enforce the requirement that a healthcare provider be licensed in the state in which they were providing services in order to get paid by Medicare and Medicaid. At the time the announcement came out, there was not a clarification about how that affected state licensure requirements, but after a while, CMS did actually clarify, and it's still clarified on their website now, that this pronouncement does not affect state licensure requirements, but what it does do is kind of loosen, along with, as I'm sure a lot of people are aware, a lot of other requirements that have been in place traditionally with respect to Medicare reimbursement and then Medicaid reimbursement to a certain extent. This loosening of the licensure requirement would permit healthcare providers to take advantage of and get reimbursement in circumstances that they wouldn't have otherwise. But again, this doesn't affect state licensure at all. This is just really basically a reimbursement rule. So next slide, please. I think this is just the point that I made, so we can go to the next slide as well. So we did see, in addition to the federal government pronouncement, we did see a lot of loosening in licensure requirements in the states, starting at the beginning of the pandemic. I think that I probably should have updated the slide a little bit more. The initial phase of activity is over, certainly, and I think that we're really, if not winding up, we're really getting to the point where these waivers are generally fairly mature and have been pretty set. Although I think that we have seen some movement in some states that has actually, have actually ended some of the licensure flexibilities. So we found that with these flexibilities, the states have taken different actions. So not all states are implementing these waivers in the same way. And I think if we go to the next slide, we can see some of the aspects that are changing. So we see that the waivers are varying based on the types of providers. So some waivers are limited to practicing physicians. Some are extended more to other types of professionals, nurses, therapists, and other types of professionals. Other factors that are varying are whether there's actually a waiver of a licensure requirement or whether there is just an expedited licensure process or authorization process to be able to provide. So we see that in some states there's still a hurdle to be able to provide the services in the state, an administrative hurdle. The filing requirements and the timing of the filing requirements are different also from state to state. As are the services that are permitted. Some of the waivers are specifically related to telehealth services and some are not. And that speaks to the modality of the services too. The modality also includes whether it's telephone interactions are permitted or whether audio visual requirements still exist, where there needs to still be a video consultation in order to provide the service, at least for the original patient or the original visit with a patient. So we'll see that there are multiple pathways in multiple states. I'm not really giving specific state examples because we just don't have a whole lot of time today, but I just wanted to provide kind of the framework of what was happening with the public health exceptions. And I think we can go to the next slide. So this slide is just a couple of places that have been really helpful over the public health emergency period to get information about what's happening with the states. I would also add the Center for Connected Health Policy to this resource page. It is something to keep in mind because there are quite some good resources on that website as well. I think that we have found, like I said, most of the states, I think all but 4 of the states actually did issue some type of waiver for some type of healthcare professions. And we're just finding that it's hard to keep up with the movements and where all of the states are at any given time. And we're concerned about what happens when the public health emergency ends. So what we're really looking forward to now is looking at how far back, or how far back the requirements will snap back into place, or whether states will be looking at continuing some sort of flexibility now that kind of the floodgates have opened. A lot of telehealth programs have been implemented. A lot of people are taking advantage of this new flexibility to provide the services. So I think that we'll probably see a mixture among the states of states just ending their public health emergency orders and just going back to the way it was before, all the way up to regional cooperation, where regions might get together and be a little bit more flexible, at least within a region, and perhaps even renewed interest in licensure compacts even beyond the interstate medical licensure compact. And we might see some of the other compacts that have tried to get a foothold, get a better foothold in multiple states, like the nurse compact and the therapy compacts. And I think that I think that's about it for my time. I know that there were several questions that have been posed during the presentation, and I'll let you.
Yeah, so I'm actually going to combine a couple of these questions,
Okay.
but it's a pretty big question. And it's actually a question that's been around even before COVID hits. And that is, what happens when you have a patient who travels out of state? Now, they're either traveling for vacation, or a lot of times you might have snowbirds moving from like the north to the south for the winter, or college students. Like, what do you do around licensing in that situation when they're traveling, or when they're traveling, but they don't tell their physician that they're traveling, and maybe the physician thinks they're still within the state? What do you do in those types of situations? You talked about COVID had some temporary relaxations, but I think probably the audience members might want to know, what do you do when the COVID relaxations also end, and what do you do during COVID?
Sure. So in some states actually permit that. That is an explicit exemption from the licensure requirement. I think, though, that some states might frown upon it as a long-term solution. So there is this concept that when you're doing business in a state, once you amass a certain amount of services that you're providing within a state, you're actually you're practicing your profession in that state. And states want to have the ability to understand who's providing professional services in their states, making sure that they're appropriately educated and vetted and background checks. So there is a point at which there might be, kind of a surge, or not a surge, or meeting the threshold of actually providing those services, practicing the profession in the state. And the state could or might take action if they were alerted to the fact that the activity was happening, and might seek to enforce their authority to regulate the practice of the profession in the state.
Okay, great. And also, just to add, because I am a reimbursement person, that even if the licensure may allow you, whoever reimburses for that service, they may have a policy that might not allow sort of like that relaxation, even though maybe the licensing laws may allow for it. There is a question about, like, what other compacts are there besides ones for nurses and ones for doctors?
I don't have the list right in front of me, but I know that there is a mental health licensure, and I'm not sure if it's psychologists. I don't know how advanced it is. Joe might have an idea as well. I just don't have that off the top of my head. I have not worked.
I wouldn't call myself the world's authority, but psychologists do have a compact. And in fact, they're trying to extend it not only across the United States, but into Canada as well. So the various provinces are at least considering making or joining that compact. That's in progress. And then there's also one for the physical therapists.
Mm-hmm. And there's one for, I think, for emergency personnel too, one out there. So let's see. I apologize if you already mentioned this, but what are your thoughts on establishing a national medical license for providers to overcome the state-by-state waiver variations?
Sounds like a great idea to me for my clients. I think that there are a lot of barriers to that, a lot of political barriers. Like I said before, states are very invested in making sure, and state medical boards are very invested in making sure that they are in control of what's happening in their state. And I think that I think as we see with the licensure compacts, not all states are willing to jump on the bandwagon and be a part of something that is that big. I think it's unlikely that the federal government would be able to impose that on the states, but there is room possibly through a Commerce Clause argument that because of the interstate nature of telemedicine now, and just the interstate medicine, the interstate nature of healthcare provision now, that there could be an argument for it. I think it would be a hard sell still in this environment.
Mm-hmm. Yeah, the Commerce Clause issue, the Obama administration did do a couple of things where it looked like they were interested in it, but this current administration, at least I haven't seen much coming from the FTC in regards to what anything related to that over the last couple of years. Yeah. All right, Amanda, thank you. We will, turn back to Amanda when we open up for our Q&A. But next, we're going to hear from Joe. So Joseph McMenamin. He is both an attorney and an MD, and is the principal of McMenamin Law Offices, a healthcare boutique concentrating on the law of digital health. Joe advises institutional and professional telehealth service providers, academic medical centers, remote monitoring services, and other clients on a broad array of medical legal questions arising from distance care and more recently from the application of augmented intelligence to healthcare in general and to telemedicine in particular. He also serves as general counsel to the Virginia Telehealth Network and as a member of the legal resource team of CTEL, the Center for Telemedicine and eHealth Law. And Joe, I will turn it over to you.
Thank you very much, May, and my thanks to NCTRC for organizing the meeting. When we began preparing for this, we felt that combining a presentation on licensure with one on the provider-patient relationship made some sense, because these are interrelated concepts, as I hope will become apparent as we proceed through the slides. May I have the next one, please? I'm a lawyer, so I start with a bunch of disclaimers. I won't read these, except perhaps the first, namely that whatever views I offer here are only my own and not that of anybody else, and specifically not those of the TRCs. Next slide, please. Oh, maybe one other disclaimer I'll mention while we're changing slides is that if I refer to the doctor-patient relationship, that's a habit, probably not a good one, and it refers in reality, unless I say otherwise, to all professionals in the healthcare fields. Next slide, please. The relationship is the foundation of the duty of care. The idea that a doctor or any other health professional owes a duty to a patient arises from the nature of the relationship between them. And in order for that relationship to exist, the law looks for an agreement, whether it's actually explicitly stated or not, that the provider has agreed to offer services that the patient requests and the patient has agreed to accept them. In the era before telehealth became as prominent as it is, many times courts would examine whether a physical examination had taken place or not. It was not the be-all and end-all, but it was considered an important criterion. With distance care, that concept still has some relevance, but it's a little more difficult to apply, since the physical exam one can do at a distance is necessarily more limited than that which one can do in person. Generally, if there is no relationship, there is no duty of care, nor is there a right to treat, or to prescribe, or diagnose, or to bill, or anything else. One could argue that an emergency could create an exception to that situation, but at least as the law looks at it, in the emergency, the patient has tacitly agreed to be cared for anyway, and so the question is really academic. Some of you may be aware of the very recent so-called telemedicine takedown that focused pretty closely on this provider-patient relationship, and in my view at least, helps illustrate why it's important. the OIG, Office of Attorney of the Inspector General of HHS and the Department of Justice moved to bring about criminal prosecution of a whole variety of actors, including a great many healthcare providers, who were making judgments about whether Medicare beneficiaries should be treated or not with various braces and other orthotics, largely on the basis of information elicited from Medicare beneficiaries on the basis of telephone calls that were placed by a call center. And the government has taken the position that the orthotics that were ordered on the basis of these interactions were improper because they were not based on a proper doctor-patient relationship and resulted in fraud to the tune of $4.5 billion, and some 300 plus defendants have been sued or have been prosecuted or will be. And so I think that illustrates this is a concept one really has to understand and apply properly. Next slide, please. The relationship can be established, at least by my reading of the law, by virtual means in every American state. What's important to remember, though, and I think Amanda made this point in obliquely, at least in her presentation, is that there's a great deal of variability from state to state. And so a mechanism that's perfectly sufficient to establish the relationship in my state of Virginia, for example, may not be right across the river in the District of Columbia or across the southern border in North Carolina. So knowing the rules in your own location are fine, but if you're going to be caring for patients outside your own jurisdiction, then it's important to understand what that jurisdiction requires, because as Amanda pointed out, the way the law looks at it, the care is being provided at the location of the patient, and the law that's applicable then is that of that patient's state at the time of the care. Now, because telemedicine, at least by legal standards, is still a relatively recent development, and for a variety of other reasons as well, there have been remarkably few reported cases in which the law of telemedicine has been explored by a court, or in which questions such as what does it take to create the relationship have been explored by courts applying a given statute or regulation or case law to a virtual care scenario. So in that situation, we tend to look, by we, I mean, I suppose, lawyers and more importantly, judges, at cases that existed before telemedicine became what it is today. We know that, again, it varies with the state, but here's a few examples, a few cases that I think are illustrative. Here's one from Michigan, the Court of Appeals, so it's a higher level judge than that whoever tried the case. And in this Hill by Burston against Kokoski matter, we have a physician who's contacted by the patient's treating doctor about treatment alternatives. And the two have this conversation about what's to be done for the patient. The court concluded that the doctor who was consulted in this way did not owe a duty of care to the patient who was discussed because, in the eyes of the court, applying Michigan law at the time, the steps necessary to create that relationship did not exist, were not taken. Since there's no relationship, there can be no duty. Since there's no duty, there can be no breach of duty. If there's no breach of duty, there's no case. The defendant is out of here. On the other hand, I shouldn't say on the other hand, but in another slide or two, we'll look at this from a different point of view. Here's an Alabama case from '77 in which it was held that a curbside consult, probably not in principle, unlike that which occurred in Hill, was not sufficient to establish a relationship. So Dr. A talks to Dr. B, and Dr. B is this guru of whatever the patient's problem is. That's great. Hopefully B helps A. A can do a better job as a result, but B does not owe a duty to the patient because B has not formed a relationship with the patient, which is critical to the whole analysis. Next slide, please. We look at a different case called Horde against the US. This is the Fourth Circuit. This means it's a federal case, not a state case, and it's an appellate level decision, so it has more authority. It is given more deference, if you will, than would be a decision handed down by a trial judge. In this case, we have a treating doctor who refers a patient to another physician for treatment for cancer. And what occurs is that the patient has some adverse effects from treatment that the second doctor provided and sued him as a result. The defendant, the oncologist who was sued here, claimed that there was no true doctor-patient relationship with that patient. Therefore, no duty flowed from him to that patient. And since there's no duty, again, no breach of duty, no case. And he pointed in particular to the fact that the oncologist, the consultant, did not perform a physical examination, which was, he argued, central to the creation of the relationship. On the other hand, and unfortunately for him, the court rejected that argument and said that because it accepted the referral and the patient had accepted the relationship, that that was sufficient to create one. Now, again, remember, this is consensual, that in general, if you're a doctor and I'm a patient, I don't know, let's suppose you're an anesthesiologist and you're on your way to the golf course, but you happen to have your entire kit in the trunk. You've got your endotracheal tube, you've got your laryngoscope, everything you could possibly want. I don't know why, let's pretend that you do. And I'm bleeding by the side of the road and you know I'm in trouble and you could stop and help me, maybe save my life. But you drive on to the golf course and let me lie there. Perhaps you know I'm a lawyer. Whatever the explanation, you are not liable for anything because you don't owe me a duty, there's no relationship between us, and the emergency doesn't change that. Next slide, please. Now, in this case, Wheeler against this hospital, this is a Texas case from '93, the court takes a somewhat different approach. Here we have a nurse who phones a doctor and asks him whether, in his opinion, the patient is stable enough to be transferred from what I assume is a community hospital to perhaps a referral center. The opinion doesn't go into a great deal of detail about those specifics. Here we have a situation where we have a conversation only between a nurse and a doctor. The doctor does not talk to the patient himself. And yet, said the court, that was enough to create the doctor-patient relationship. The duty existed at the time that the physician evaluated the patient's status and approved the transfer, notwithstanding that that evaluation was based wholly upon whatever the nurse had to say about the patient's history, physical findings, lab data, whatever else might have been disclosed in that conversation. That was enough, at least in Texas in this case, to create the relationship. Next slide, please. Once that relationship is created, of course, then all the consequences flow from it. There's a duty that could potentially be breached. Now, in this next case, this one is from South Carolina from '96. We have an interesting situation where a doctor is engaged not by the patient directly, but rather by the patient's employer for a pre-employment physical. This scenario comes up with some frequency. The doctor examines the patient with the sole purpose of determining whether this individual is capable, physically capable of handling the duties of the job that he or she, I forget, I think it's she, applied for in this particular instance. And the physician concluded, yes, indeed, she had sufficient strength and mobility and whatever else was needed to take this position with the Ball Incon Glass Packaging Company. In the course of working her up, in the course of evaluating the patient for this, to answer this question, the doctor noticed that she had some moderate or mild hypertension, and said to her, look, you know, you really, you're not here for this, and it won't stop you from taking the job. You can go ahead and work, but you do have elevated blood pressure. You really ought to check with your doctor about that. You may need to be treated. High blood pressure has serious consequences. But that was it. No further workup, no effort to determine whether this might be secondary as opposed to primary hypertension, certainly no prescribing of anti-hypertensive agents, nothing of the sort. And as I recall from the facts, I think the patient stroked out, and the family sued the doctor who did the insurance physical, sorry, not the insurance physical, the pre-employment physical, saying you should have done more to prevent this tragic outcome. And what occurred was, even though in South Carolina, the question whether a doctor-patient or provider-patient relationship exists is typically one for the jury, the trial court decided that this was open and shut, that this was so obvious, so clear, and only one possible rational conclusion could be reached. There was no reason to entrust this decision to the jury. So the trial judge entered what's called a directed verdict, which essentially is an order by the court to the jury saying, thou shalt find no liability here, because there isn't a relationship of the type that this person could sue upon. And on appeal to the appellate court, that decision was upheld. Here, said the court, we don't have a typical situation. We have a doctor who's simply trying to determine whether this patient should be hired or not, and that's not enough to ground a case. Next slide, please. So these things vary, not only with the state, but also, of course, with the facts. I think that's the one we've already seen. If you could move on to the next one, thank you. So how does all this work out in a virtual context? How do we determine whether, in a given set of facts, the relationship is properly created or it is not? Again, there aren't many reported cases. If you ask a lawyer, what's the law on subject X, assuming you can get a good answer, it's because there's a statute on it, or maybe there's a statute and a couple of regulations, or maybe there's a statute, a couple of regulations in 16 cases. And if you've read all of that, the chances are you've got a fairly good idea what the state of the law is with respect to the issue in hand. But here we don't have that much help, unfortunately. So, and the answer to the question is important because it determines whether you are in a position to treat. It determines whether you need a license in the patient state unless there's some special situation as we have right now with the waivers under the PHE. And it also means, by the way, that you have malpractice liability exposure and you should be insured against it, among other consequences. Well, because we don't have a lot of actual virtual cases to look at, true telemedicine cases, what judges often do is they will look at cases that arose in the days when this question was framed, most often when the communication was by telephone. No video, no high tech, nothing sophisticated, not traditional telemedicine as we've come to understand that term, but a telephone audio only communication. The judges in the past have looked at such things as whether in the course of the conversation, whether it was between the doctor and the patient himself or the doctor and some other provider, like the treating doctor at the time or the patient's nurse, did the allegedly involved physician, the one as to whom the relationship is claimed to exist, did that doctor or that provider know the patient's name? Did that provider have access to that patient's old records or not? And of course, in a lot of phone cases, the answer is no. Did the provider actually communicate directly with the patient or instead rely solely upon information gleaned by conversations with other providers? And I think Amanda alluded to this, was a fee charged or was this strictly pro bono? Next slide, please. Answers to those questions guide courts in making judgments about whether the relationship exists or doesn't. I picked this White against Harris case because I think it's because it's as close to a true telemedicine situation as I was able to find. We have here a clinical trial, not conventional healthcare. And the defendant is a psychiatrist who had agreed to participate as an investigator in this clinical trial. He, pursuant to the protocol of the investigation, did conduct an interview of the patient for a fairly protracted period of time. And at the end of it, made some suggestions about what should be done for the management of this patient. But he never examined the patient. And although the court does not explicitly say so in its published opinion, I get the impression from reading it that he did not do a formal mental status examination either. And so, said the defendant doctor, I don't know any duty, therefore the bad outcome can't be pinned on me. Unfortunately for him, that effort failed. And according to the Supreme Court of Vermont, of course, the highest court in the state, the supreme authority on interpretation of Vermont's law, the interaction described was enough to establish the court used the phrase limited doctor-patient relationship, not a phrase I'm accustomed to saying, sufficient to establish a duty of due care. Next slide, please. So these are very fact-intensive matters, and it's going to vary a lot. We don't have time for a full treatment of the prescribing issues, but Amanda alluded to this briefly. If one is to prescribe a medication for a patient, whether it's aspirin or whether it's chemotherapy, one needs to have a doctor-patient relationship or prescriber-patient relationship with that patient pursuant to the laws of that patient's state. Sometimes you can learn enough about the physician practice law, the medical practice laws of that state to be able to determine that. Oftentimes, though, you also have to look at the state pharmacy laws and or at common law, case law that's been handed down, in order to know the answer to that. Once that relationship is established, then you can, in the exercise of your own professional judgment, prescribe for that patient in whatever manner seems appropriate, subject to restrictions pertinent to controlled substances. And of course, just as is true in in-person evaluations, off-label prescribing is perfectly permissible by telemedicine just as well. Next slide, please. For controlled substances, there is a federal statute known as the Ryan-Hyde Act that could easily be the subject of a webinar unto itself. But the basic concept of the Ryan-Hyde Act, enacted in the wake of the unfortunate death of a young man who had got access to a drug of abuse by means of using his parents' credit card, an in-person examination has to be conducted before a provider is permitted legally to write for controlled substances, no matter how well indicated they may be clinically. When the act was enacted in 2008, 7 exceptions were created for the practice of telemedicine. Unfortunately, most of them are very narrow and not terribly helpful for most practitioners If, for example, you spent your time caring for folks living on Indian reservations, that would be an exception that would allow you greater freedom in writing for these drugs for those patients. But most docs don't fit that description, neither do most mid-levels with prescribing authority, et cetera. Now, an exception that up until 2020 was not of no real value, but is now critical, is the public health emergency exception. On January 31 of this year, Secretary Azar declared one. I think I have a typo there. That should be 20, not 21. Sorry. It has been renewed several times since then. And under the public health emergency exception, an in-person examination is not necessary unless you're in a state that so requires. Because remember, we're under two sovereigns, not only the federal government, but also the state. And there's some states that have laws on this as well. But assuming the state does not, and for the duration of the PHE, but only for the duration of the PHE unless the law is changed, the in-person examination is not necessary so long as it's in the ordinary course of professional practice. Next slide, please. I thought maybe we're near the end. Yes. Thank you. I'll turn it back over to May for Q&A. Thank you all very much.
Thank you, Joe. You got a couple of questions in here. The first one is, what are core items that establish the relationship that will be legally held valid?
It's going to vary with the state. But in general, and I'm assuming we're talking about a telemedicine context, and again, with the caveat that we don't have a lot of a precedent to look at here. But generally, if my guess is correct, the courts are going to take a leaf from prior history and will look at such things as whether in this particular encounter, the provider knew the patient's name, probably did. Whether the provider had access to the old records, that's a tougher question if we have direct to consumer, for example, but maybe not. Did the provider conduct an examination within the context, within the limits that telemedicine permits? Did the doctor do this? I say doctor, did the provider do this for a fee, or did he do it, she do it, gratis? These are things that are likely to be relevant. Now, the good news is that at least to a degree, many states have been more explicit by means of statute, sometimes by means of regulation, in writing down and making therefore available what is or what is not adequate to establish a doctor-patient or provider-patient relationship in a telemedicine context than is the case in in-person care. That's an overgeneralization, but I think it's fairly reliable. So there's a decent shot at checking in, if you're offering services in Wisconsin, checking to see what Wisconsin has to say on this subject. And you may have the good fortune to be able to find actual authority that answers that question and takes away the guesswork. And of course, if you do, then follow the instructions, essentially.
As a follow-up to that, and I've heard this question come up a lot of times, Joe, are you familiar with eConsult? And that is the consultation that somebody does over an asynchronous type of platform, basically, where a primary care provider sends over all the information to a specialist like emails back their sort of like recommendations, but the care stays with that primary care provider. And there's been debate about that among the eConsult folks on like, does that establish a patient-provider relationship with that specialist?
Well, I think you've nailed it, May. There's been a lot of debate. There's not been a great deal of clarification, at least not that I know of. Amanda may know better. But at least to my knowledge, that's still largely unexplored territory, largely unknown. I think probably the safer approach, and I tend to think about risk, is to assume that if you're consulted in that way, as an e-consult, as you just described, that it is a valid doctor-patient or provider-patient relationship, at least for purposes of potential liability, and you should be guided accordingly. A somewhat harder question is, well, is it sufficient for you to prescribe? And I don't know that I think the jury's out on that, but what I would certainly anticipate is that to the extent that an e-consult reflects an effort on the part of a primary care provider or someone else who is actually in the physical presence or could be of the patient, it may be prudent to, assuming that it can be done, to allow that person, whoever the provider is who's with the patient, to make decisions about prescribing and to write for those prescriptions for the sake of avoiding potential violations of the practice of medicine laws in that jurisdiction. Is that responsive?
Yes, it is. Thank you.
And Amanda, did you want to weigh in on this?
Yeah, Amanda?
I didn't have anything to add. I think that makes a lot of sense here.
Mhm. There was a specific question to one of the slides you had, and I believe it's involved the case where the nurse did the consultation with the doctor, and it said, in that situation, is it important that it's a licensed provider to a licensed provider? What if the person was an MA?
The short answer I would give is yes. I would think that relying upon information relayed by a person not licensed is risky and probably not sufficient. And frankly, I would ask, why would it be necessary in most cases for an MA or some other person, however well versed in his or her field, to play that role? Why could we not get a nurse or some other licensee to play that role? And I mean, maybe there are circumstances where that's really not practical, but I would be loath to rely upon the MA as the conduit for creating the relationship.
Mhm. How are controlled substances, medications, assisted therapies handled via telehealth, considering typically these prescriptions would need to be provided in hard copy?
Very good question. And what is sometimes necessary is to do just that. You can prescribe the medication, but you have to send a script, a paper script, to the patient's pharmacy, which is, apart from the hassle, can involve considerable delay that may be clinically less than desirable. But while there's been progress, some progress anyway, in making it easier and making it more efficient to prescribe these medications through virtual means, we're by no means at the end of we by no means crossed the goal line. I would very much like to see some clarification and some simplification. But I would say for now, and in the absence of that, it's best to treat it for documentation purposes pretty much the same way you would for an in-person evaluation. Now, that's a problem. That's not ideal. That's not the greatest thing for the patient. And it's frankly not the greatest thing for the provider either. But it's probably the safest way to go.
So this one is actually, both of you, I think you might have an answer to this. Are providers' practices, in addition to their person, required to be licensed in the state they are providing services in? I.e., can a provider be individually licensed in a state, but their business is not?
I'll go ahead and tackle that one. There's a difference. So I think that we're not necessarily talking about licensure as in medical licensure for a physician practice. What we're really looking at is whether the physician practice or other type of practice is qualified to do business in the state in which they're providing the services. And I think generally there are some corporate practice of medicine nuances here, but generally we find that if a provider is providing services in a state and at a threshold that makes them doing business, that the state would be consider them doing business in that state, the state would say, yes, you need to be registered in this state. Either your existing practice needs to be foreign qualified, which means that the state recognizes that your organization that's organized in another state can practice the profession in the state, or you would need to set up a new organization depending on whether the state, the new state, permits foreign qualification of out-of-state practices, and the states are different. So you would just definitely need to know. So we find that when we're doing a rollout with a client of a 50 state telehealth strategy, we find that we end up with a structure that is, I don't know, 6 to 8 practices that practice in 50 states in various formations.
Mhm. All right, we have time for maybe one or two more questions. So this question, again, one that I see frequently is like, what do you do when your patient is traveling out of state and they need a refill on a prescription? Can you just call the pharmacy in that different state, and is that legal?
This question comes up a lot. The scenario comes up a lot. And I'm willing to bet that pretty much since the time of Alexander Graham Bell, doctors have been doing just that. But at least to my reading of the law, strictly speaking, that is not lawful unless there has been a waiver as under the PHE and you're in a state that has such a waiver, or there's some other circumstance that makes this different. But strictly speaking, if the patient is in state X, whether it's lifetime or it's for 10 minutes, the law that pertains to this interaction is the law of state X. The provider should be licensed in the law in state X. If that provider is not so licensed, then this is the unauthorized practice of medicine, potentially vulnerable to sanction by the Board of Medicine that has jurisdiction of his license. Now, that's as I see it, that's a law school answer. The practical answer is that this happens every day of the week and has been happening for decades. And unless the board, the relevant board, the board that has the doctor's license, or boards plural if that's the case, finds out about it, nothing's going to happen. How would such a board find out about it? Because somebody files a complaint. Now, if the patient is perfectly happy with this arrangement, who's going to file that complaint? And if no complaint is filed, how will the board even know? And if the board doesn't know, nothing's going to happen. So I guess my basic answer is no, it's not proper, strictly speaking. And yes, you should be licensed in that patient state. But you also have a duty to the patient. You want to try to do the best you can to provide healthcare to that patient. That's when you're in the business of doing. And it's, I guess, at the end of the day, a question of risk tolerance. If you're willing to accept the gamble that nobody's going to complain about this, the board won't find out, and everything will be fine, you can probably do it. If, on the other hand, you're worried about that, then the smarter, safer thing, even though it's unfortunate for the patient, is to decline to do that and to say, I'm sorry, I can't help you. I'm afraid you have to see somebody licensed in that state. You might want to go to the local urgent care or whatever.
Okay. Thank you. And I'm sorry that's all the time that we have today. So I want to thank Joe and Amanda again. And for those of you who enjoyed this, they will be back next week talking about liability and privacy issues. So that is our next session is on November 18th. You can definitely register for it still. Also know in December, we will be doing a special series in conjunction with the American College Health Association. Those sessions will be on December 7th and December 10th. Registration information is on the TRC website. You'll also get a short evaluation after this webinar, and it will really help us out if you fill that out. The recording for this webinar will be up within 24 hours on the NCTRC website and our YouTube channel. I want to thank you again for attending the session, and thank you to our great speakers, Joe and Amanda. Have a great day. Bye, guys. Thanks.